The committee will come to order. Let me rephrase that. The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today for a hearing on litigation affecting the stone slab industry. And many times today, we will probably be showing this product that is, even by Dr. Michael's analysis, completely safe in its current form. So I'll be touching it, I'll be holding it, and I will have no fear. I now recognize myself for without objection, Mr. McClintock and Mr. Correa will be able to participate in today's hearing and for the purpose of questioning witnesses, and without objection, so ordered. I now recognize myself for the opening statement. Our hearing this morning examines the troubling rise of abusive litigation against U.S. stone slab industry. The stone slab industry contributes around $30 billion to the U.S. economy and employs about 100,000 workers. Stone slabs are used for many uses, but the most prominent in all of our homes would be as a effective, low-cost, hard surface in kitchens, bathrooms, and other countertops, integral to both residential and commercial use. Unfortunately, a series of events, including the growth of illegal immigrants working in unregulated and unlawful fabrication facilities, has created many people who have been injured by ingesting in an unprotected way the dust during wrongful cutting. These bad actors cut corners in their fabrication shops when it comes to workplace health and safety in violation of federal and their state laws. The result has been a race to the bottom that has resulted in vulnerable workers at these fabrication shops contracting silicosis, I told myself I'd be able to say that, silicone-related disease by ingesting it into their lungs. This results in from the released and inhalation of silica dust, a naturally occurring element in many industry and consumer products throughout fabrication. When it's processed by grinding or cutting, it becomes exactly what you do not want to inhale. OSHA and many state regulated authorities, including those in California, have long-standing standards, guidance to avoid worker exposure of this hazard. As a matter of fact, during one of our witnesses' times as the head of OSHA, Dr. Michaels was there at the time in which there was a significant reduction in what would be considered a safe level, and that standard is still the one we use today. Reputable fabricating firms follow best practices. This includes, at a minimum, a process of water to make sure the dust doesn't accumulate, and then the extraction of any materials and the cleaning of the water. Moreover, many of the fabricators use state-of-the-art, completely enclosed CNC machines, meaning no one is there during the process, and it can be completely free of any dust getting into the factory. This best practices, though, does not, and I repeat, does not exempt the litigators from going forward and suing those people, even though they can demonstrate that they were well below Dr. Michaels' acceptable level, basically being at the naturally occurring level and with no elevation. The option to be unsafe doesn't come without a cost. Companies who implement this have, by definition, higher CapEx for the machines, higher cost of processing, but these best practices are what people do for their employees. The bad actors, by contrast, are disproportionately, and particularly in my home state, using undocumented workers who, in fact, have no ability to report that they are, in fact, being abused until or unless they become sick, and then it becomes public knowledge. These opportunistic plaintiffs, though, are not seeking to shut down the bad actors. As a matter of fact, the bad actors often are not even sued, or if they are, they simply roll up and go away. What they're doing is going after companies who may not even have seen the slab, touched the slab, or in any way processed the slab. Literally, companies that bring product in bulk, often by ship or rail, and then put it onto a truck and disperse it to people who do fabricate it or who do sell it to fabricators are the target. Why? Because they have money. This is not a new practice, but it is a practice that is, in fact, causing a bankruptcy and a reduction in those who are operating legally. If you eliminate the people that are operating legally and using best practices, there's no question at all, you by definition are empowering those who will do it clandestinely. In my own district, some 70 or about 100 miles south of Congressman Carrera's district is the Mexican border. It is fairly easy to process over the Mexican border and bring the product back duty-free, which means if the legitimate players who are playing by the rules and investing vast amounts of money simply export these bad practices south of the border, where the kind of protection that exists in the U.S. by law does not, they will simply be having many people in another country injured. This and other areas are the reason that we're trying to both go after the bad actors, and today in this hearing, we will hear from those who are being impacted in their small or medium-sized businesses by being a target, even though they are either using best practices or, in fact, have not even touched the material. I'm going to play a short video to set the stage for what we've been talking about for everybody, and then I'll recognize the ranking member.
In stone surface fabrication, workplace safety is crucial, especially
For everyone, this is an example of a machine where both water are being used, the water is being reclaimed, but most importantly, no person is there. It's completely sealed. So it's a double safety capability.
Silica, a common component in many stone surfaces, becomes hazardous when improperly cut, ground, or polished by releasing fine dust that is harmful when inhaled. Whether using hand tools or fully automated machinery, wet processing is one of the most effective engineering controls to manage silica dust by using water to prevent dust from becoming airborne. Regardless of size and equipment, every stone surface fabrication shop must adhere to all federal and state OSHA regulations and requirements, especially in regards to respirable crystalline silica. Following wet cleaning protocols, using appropriate personal protective equipment, ensuring proper ventilation, training workers, and maintaining a compliant air testing program. Water is key for a safer work environment. Water-fed hand tools help manage dust during cutting, grinding, shaping, and polishing. The right volume, quantity, and delivery are critical, and a robust water reclamation system ensures water is efficiently reused within the fabrication shop. Beyond dust suppression, wet processing reduces tool wear, improves product quality, and keeps the workspace cleaner. When you implement wet processing and diligent housekeeping throughout the fabrication process, you help manage silica dust and create a culture of safety for your most valuable assets, your people. Contact your local OSHA consultation office directly or consult with an industrial hygienist for additional information. If you want to learn more about Cambria, visit us online or contact your regional product representative. Cambria, where safety and quality are non-negotiable. Family owned, American made.
Okay, would you play the second one? It's shorter. Those are masks that are not, in fact, protecting the person. There's no wet activity, and this is one of those shops of which there are many, many of them. Dr. Michaels, I'm sure, is aware of it. With that, I will recognize the ranking member of the subcommittee for his opening statement.
Thank you, Mr. Chairman. Workers across the country are getting sick and dying of an entirely preventable disease. This disease is called silicosis, and it happens when silica dust and other toxic materials are inhaled into the lungs over and over again. Toxic particles are trapped deep inside workers' lungs, leaving them struggling to breathe. Silicosis has no cure, and it's a death sentence. Many of us from Georgia hear silicosis, and we think of the men and women who worked in the mines their whole life. But this silicosis epidemic is caused by working with a material called artificial stone, in other words, fake stone, and it makes workers sick faster and younger. Doctors are seeing patients in their 20s and 30s, men with families and young children, so sick that they require double lung transplants, so sick that they can no longer work and no longer provide for their families, so sick that they slowly and painfully suffocate to death. Fake stone produces dangerous toxins when it's cut, and there's no way to use a fake stone slab without cutting into it. So artificial stone or fake stone has a higher concentration of silica, and the particles it produces are smaller, which can evade safety standards on the books for handling products like silica. So why are we having this hearing today? Surely we must be here to talk about how Congress can protect workers from artificial stone silicosis. No? Maybe we're here to talk about how the workplace safety standards currently in place aren't doing enough to keep fake stone workers healthy. Not that either. Perhaps we're here to discuss how we can make it easier for stone fabrication workers to unionize so that they can negotiate better health and safety protections for themselves. Nope. So if not to address the problem of workers being poisoned on the job, why did my colleagues across the aisle call this hearing? Apparently, it's to give a handout to a millionaire friend of none other than Donald Trump. The bill behind today's hearing would give blanket immunity to fake stone manufacturers and suppliers, preventing injured workers from seeking justice in court. It would dismiss the hundreds of cases pending against these manufacturers, and Congress would make a multi-millionaire CEO, make that millionaire CEO's problems go away just like that, while the workers who cut, grind, polish, and install this dangerous product struggle to make ends meet. Struggle to stay alive, actually. For those of you who are saying someone else is to blame, that employers are the real victims or real villains, our courts determine liability all the time. People petition the court, have their grievances heard, and a judge and jury consider the evidence, and a judgment is rendered. Manufacturers are asking for a different scenario. They want to unlevel the playing field even more, one where the deep pockets go to Congress, Congress makes a snap judgment, and the big businesses never have to go to court again. That's not how the justice system is supposed to work, ladies and gentlemen. And I condemn the blatant misuse of this committee to shield corporations at the expense of the American worker. I am not here to give artificial or fake stone manufacturers a bailout. I'm here today for Mitchell Boulware, a Georgia resident who's owned and worked at a stone fabrication shop for over 2 decades. Mitch and his son Jacob, who started working in the shop as a teenager, have both been diagnosed with silicosis. Because of shortness of breath and constant fatigue, Mitch is no longer able to work. Workers like Mitch and Jacob have every right to go to court and ask for justice from those who caused them harm. And it is unconscionable to propose that we take that right away from them. So thank you, Mr. Chairman, for calling this hearing, not because I support this bill, but because this hearing has provided the opportunity to tell the stories of workers like Mitch and Jacob, workers who deserve our attention and our respect, and they are dying. And they deserve the opportunity, like everybody else working in this country, to bring their case to court. And with that, I yield back.
Gentleman yields back. I now recognize the chairman of the full committee for his opening statement.
Thank you, Mr. Chairman. It doesn't look fake to me. It looks pretty real. This idea this is some fake stone industry. This is a real industry where we got real problems going on. Everyone wants to protect workers, but you don't want to drive a $30 billion industry out of our country, which is where this thing is headed. So I appreciate the chairman having this hearing, appreciate the witnesses who are going to testify, and I look forward to their testimony. With that, I yield back.
The gentleman yields back. Now recognize the ranking member of the full committee for his opening statement.
Thank you very much, Chairman Issa, and thank you to our witnesses for joining us today. The House Judiciary Committee, of course, is not a jury. We're not a courtroom, and when we do our work right, we're facilitating the proper execution of the law and the protection of the rights of the people in courts across the land. That's our proper role. I feel like we're somehow being invited to be jurors today, but in any event, I'm happy to learn about a very serious workplace-related injury that's taking place in the country. Acute silicosis is a disease that renders your lungs useless. You struggle to breathe as fluid fills your lungs up, cutting off your oxygen supply. There's no cure for it. If you don't get $1 million double lung transplant, you effectively drown on dry land. Even the lucky people who get an organ transplant can extend their lives only by a few years. Silicosis is a killer. It's contracted when workers who fabricate artificial stone inhale nanoparticles that settle in the lungs. They're so small and so plentiful in artificial stone that they can escape any respirator and evade any protections designed for avoiding harms from silica in natural stone, like wet saws. Medical experts who treat silicosis patients agree that the only safe way to cut artificial stone is to wear a full hazard suit or to have machine-only fabrication, neither of which is apparently yet technically or economically feasible. Now, I confess I knew nothing about any of this before this hearing was scheduled, but as I researched this horrid disease, I was pleasantly surprised to learn that our colleagues were suddenly focused on a severe health crisis afflicting working-class craftsmen across America. I simply assumed they were moved by the same headlines and articles I was reading, like one saying, Southern California man with silicosis wins lawsuit against makers of artificial stone slabs, or jury finds stone companies at fault in lawsuit by countertop cutter sick with silicosis. And California workers who cut countertops are dying of an incurable disease. Alas, I'd fallen victim to magical thinking. Our colleagues were getting involved in this rather esoteric matter, not to help the workers, but to help the industry they work in, and specifically the Trump mega donor, who is the only major domestic manufacturer of this artificial stone and is working like Houdini to escape liability for any and all of the injuries caused by the business that he's involved in. We are here for one reason and one reason only, because the jury system and because American tort law are actually working for the people who work in this field right now. The workers are getting extremely sick, and courts are finding that artificial stone manufacturers are at least partially at fault for it. So what do my colleagues across the aisle propose to do? Do they want to ban artificial stone? That's what they did in Australia as an inherently dangerous substance. No. Do they think we should prosecute the artificial stone CEOs for a deliberate or negligent failure to warn workers, as Spain did in 2023? No. Do they want to let our American court system do what it does best and hear claims on a case-by-case basis under the general principles of American tort law and products liability? No. They want, as I understand it here, and I would love to be corrected, they want to immunize the big, primarily foreign-owned manufacturers from being held accountable for the results of this process in our court system. I'll close with this thought, Mr. Chairman. There was a brief fleeting moment when our colleagues across the aisle struck the pose of being the party of the working man. I remember it well. Donald Trump promised in 2016, 5-10 years from now, we'll be a different party. You're going to have a workers' party. On the campaign trail in 2024, now Vice President J.D. Vance told a crowd, we need a leader who's not in the pocket of big business, but answers to the working man, union and non-union alike. Even just 2 months ago, long after this fantasy had passed for most people, Vance said in an interview with Breitbart News, we've got a lot of working class voters who frankly don't care what was Republican orthodoxy 25 years ago. They're pushing the party in a different direction. Well, my friends, if anybody wants to hang on to the fading embers of the idea that the GOP is the party of the working class, this hearing should put an end to that fantasy. Immunizing employer corporations who repeatedly, knowingly subject workers to the kinds of hazards involved in this process and then want to escape all liability is not an agenda that would be embraced by the party of the working class. Thank you, Mr. Chairman. I yield back.
I thank the ranking member. I will note that the foreign manufacturers are outside the reach of the very courts that we'd like to have enforce. Only a domestic manufacturer finds himself in that litigation. And with that, I'd like to introduce our witnesses. And without objection, all opening statements will be included in the record. We begin with Ms. Rebecca Schultz. Ms. Schultz is the Chief Legal Officer at the company whose video we saw, Cambria, a family-owned manufacturer of quartz products based in Minnesota. The products are used in homes, schools, restaurants, hospitals, businesses across the country. Mr. Jim Haib is the Chief Executive Officer of the Natural Stone Institute, an association of manufacturers, dealers, and other stone industries. He also serves as Executive Director of the Natural Stone Foundation, it should be institute also, a nonprofit organization that focuses on education, advocacy, and standard development. And I will note at this point that we will be talking about manufactured stone a great deal, but the standard, even according to Dr. Michaels, is a single standard, whether it's natural stone or manufactured in a composite. Mr. Gary Tawa is the Vice President of the Natural Stone Resources. It's a family-owned stone distributor based in California. The company sells their products to wholesalers and distributors and is not a fabricator. Dr. David Michaels. Dr. Michaels is a professor at George Washington University's Milken Institute School of Public Health. He previously served as the Assistant Secretary of Labor for OSHA during the Obama administration, and as I previously said, was instrumental in the standard that we'll be talking about today. Before I begin their opening statements, I would ask that all witnesses rise to take the oath. And please raise your right hand. Do you solemnly swear or affirm, under penalty of perjury, that testimony you are about to give will be true and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Please note that all witnesses answered in the affirmative. In addition to other material you may want to submit, your written statements are already in the record in the entirety. So I ask that you stay within the 5-minute guideline. The lights give you a good indication of green, yellow, and red. Even in California, we know what that means. And that if you get close to the end, please summarize so we can close and move on. We'll begin with Ms. Schultz. Oh, and we always have to tell at least one person to push that little button. You got to be the person.
It's because I'm first. Good morning, Chairman Issa, Ranking Member Johnson, and members of the subcommittee. Thank you for the opportunity to testify today. My name is Rebecca Schultz. I'm the Chief Legal Officer of Cambria. Cambria was started in 2001 by the Davis family, who leveraged their experience in cheese making to open the first domestic quart slab factory in the small rural community of Le Sueur, Minnesota. This here is our product. Our industry and the many thousands of workers it employs, including 1,800 workers at Cambria, face a serious threat. Despite complying with all applicable law, including OSHA regulations, we are under attack from hundreds of lawsuits. The lawsuits are being filed by workers who have very tragically developed very serious occupational diseases, including silicosis, as the result of working at dangerous workplaces. This is unacceptable, and their employers must be held accountable. Cambria has no control over these third-party businesses and their dangerous conditions. We don't own them, and we don't operate them. But rather than hold the bad actors accountable, the lawsuits are being filed against dozens of innocent stone slab manufacturers. The wrong parties are being sued, and the lawsuits are overwhelming good companies throughout our industry. That is why we support H.R. 5437. A nationwide ban is also not the answer to dangerous fab shops clustered in California. Union representatives at last month's Cal OSHA Standards Board meeting, which I attended, opposed a proposed ban in California because they explained that fabrication can be done safely. The issue is the non-compliant workplaces, and California jobs are on the line too. According to the data that Dr. Michael cited, 98% of the 481 cases reported by the California Department of Public Health are in Latino males. Please keep in mind, there is only a handful of silicosis cases in the other 49 states. It's absolutely horrific that members of this vulnerable workforce in California are being exploited and exposed to indisputably dangerous conditions. And it's outrageous that these American sweatshops are not being shut down. What those of us in the industry know is that fab shops cut many types of stone, both quarried and engineered, or what we call quartz. And when these stones are cut safely, workers are not overexposed to silica dust. But when the stones are cut unsafely without water, the workers are overexposed to silica dust, often many times above OSHA's permissible exposure limits over an extended period of time. The problem is the process, not the product. We know quartz can be cut safely. At Cambria, we own and operate 3 fab shops that serve several Midwest markets. 1,000 Cambria fab shop employees have spent more than 10 million hours fabricating over 650,000 quartz slabs without a single reported case of occupational disease. Again, we only cut our own product. It's exclusively quartz. This demonstrates that quartz can be fabricated safely. And as you saw in the video played earlier this morning, there are no hazmat suits or robots at our factory. Our workers are protected. We invite all members of the subcommittee and Dr. Michaels as well to come to Minnesota and visit us and see how we fabricate our slabs safely and that our employees are protected. The enormous resources required to defend against these lawsuits, coupled with the potential risk of nuclear verdicts, place an enormous burden on us. The legal fees for just one trial can be millions of dollars, and we are currently defending against 400 of them. Litigation overreach against the manufacturers and suppliers of stone will not fix the problem of the illegal shops in California. This legislation should be without controversy. It restores a foundational principle of American law, that liability should follow fault. I look forward to answering any questions that you might have. Thank you.
Thank you. Mr. Heeb.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you for the opportunity to testify before you today and share the perspectives of the natural stone industry on this important issue. And many thanks to Congressman McClintock for introducing this bill, which brings fairness to the sellers of stone slabs. My name is Jim Heeb, and I serve as the CEO for the Natural Stone Institute based in Oberlin, Ohio. The NSI is the leading trade association representing the natural stone industry, and our membership includes many of the industry segments most directly impacted by this important silica issue, notably stone fabricators, stone distributors, quarriers, and tooling and equipment manufacturers, and the average number of employees for our members ranges between 20 to 30. First and foremost, we care deeply about the safety and well-being of workers. The men and women who quarry, fabricate, transport, and install natural stone are the backbone of our industry. Their health and safety is paramount, which is why the NSI operates a robust, comprehensive silica and workforce training program, which is provided free of charge to companies across the nation, regardless of whether they're a member of our association. As a result, thousands of employees across the United States have been trained on silica awareness and best practices for reducing exposure. We have also been extremely active in California, operating facility tours, collaborating with Cal OSHA and public health officials, and so much more. However, despite our efforts and the efforts of so many, some employers continue to disregard the importance of safety for their workers. While we must continue to focus on workplace safety, we cannot ignore the plight of those companies which sell stone slabs, which in my industry are quarriers, stone distributors, and others. Today, their businesses are increasingly facing lawsuits for selling building materials. Selling stone slabs does not cause silicosis. It is the disregard for safety compliance when cutting and fabricating stone slabs that creates the risk. And it is wrong to shift responsibility from non-compliant third-party employers. The vast majority of companies impacted by these lawsuits are, in fact, small to medium-sized employers who asked me to be here today to help tell their story. The story of a distributor in California facing 45 lawsuits, rising litigation costs, their insurance premiums have doubled. Now they're considering closing their business after 26 years, and 142 jobs impacted. Or another who employs just 14 employees, but are facing 40 lawsuits. They told me, why am I being penalized for another company who is not keeping their employees safe? A distributor in Texas with 50 employees shared, we feel like we have a target on our back. We aren't running the non-compliant company. This feels like a money grab. Another in New Jersey said, we don't have any lawsuits filed against us, fortunately, but we've already been notified by our insurance company that they will be dropping coverage because of the silica issue. Another distributor shared, we have 46 lawsuits filed against us. The financial burden is just so difficult, we're getting ready to let go 66% of our staff. Now, a tooling company with 30 employees shared, we're going to go bankrupt if something doesn't change. So I would note that while this bill does not address tooling companies, nor does it recognize fabrication companies of all sizes, small and large, who are doing the right thing, carrying workers' compensation, collaborating with OSHA, and investing to keep their employees safe, I would love to find a way to recognize them as well. And finally, a quarrier in Utah, quarrying natural stone, said we are facing 20 lawsuits filed in California, and we don't even sell products into California. And the list goes on, all with the same outcome. Companies are being targeted in lawsuits for injuries incurred in someone else's facility. This doesn't seem right. In closing, government and industry collaboration must continue. Bad actors need to be shut down. More enforcement is needed. Trade associations will continue to offer training and other resources, and let the party that is causing the injury be liable for that injury. I urge passage because it brings fairness in our legal system. And Chairman, I would love the opportunity to work with your staff to bring forth some of the amendments that I mentioned, and happy and thankful to be part of this conversation. Thank you.
We always welcome expertise in our ability to legislate, and I know Mr. McClintock would be saying that if he had the gavel right now. Mr. Tawa.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, my name is Gary Talwar, and I'm the Vice President of Natural Stone Resources, a family-owned stone distribution company in Anaheim, California, facing 65 silica lawsuits, higher insurance premiums, and mounting litigation costs. Thank you for giving me the opportunity to share the history of my family's business with you today and how the silica lawsuits are impacting not only us, but the entire fabric of our industry on an issue we all take very seriously. It truly is an honor to be here today. I'd like to begin by telling the story of how my parents came to this country and built our business from the ground up. In 1980, my parents immigrated from India, choosing to come to America because they believed in the American dream. When they arrived, my dad took a job in my mom's uncle's warehouse doing physical labor, lifting 100-pound bags of rice and doing whatever needed to be done. My mother was pregnant with my elder sister at the time, also working for him as a cashier. She was back to work 4 days after giving birth, with my sister joining her behind the register in a portable crib. Soon after, my father took an entry-level job at Taco Bell and worked his way up to become a manager. By 1990, my parents decided to take the big leap and open their own fast food restaurant in Manhattan Beach, California. In 1999, my mom's brother in India helped my dad get started in the stone business. My dad essentially became the U.S. sales office for the family stone factories in India, selling direct to large distributors across the country. I started working for my dad in 2002 during my school breaks. In 2005, we leased our first warehouse, where I was actually our first forklift operator. By 2008, we expanded into the building next door, and in 2014, we moved to our current headquarters in Anaheim. Today, we have 2 locations in Anaheim. We distribute from a facility in Atlanta, and we import about 3,500 different products from 17 different countries. But most importantly, we employ 70 great people who we truly consider part of our family. In short, this is a story of the true American dream. That history matters because it explains truly what's at stake today. Silicosis is very serious, but an absolutely preventable disease. Worker safety matters, and no one is denying that. The real issue at the heart of this problem is unsafe workplaces, specifically fabrication shops that are not following established OSHA regulations. NSR is a distributor. We do not fabricate stone. We do not operate fabrication shops. We do not control the safety standards or practices used when stone is cut, nor control whether a shop uses wet cutting, ventilation, or PPE. Yet, distributors and manufacturers, many of them small family-owned businesses, are increasingly being named in lawsuits for injuries tied to unsafe third-party fabrication practices. NSR doesn't even sell to fabricators, and like most distributors in our industry, our role ends when the slab leaves our warehouse. At NSR, we take workplace safety seriously and conduct monthly OSHA trainings for our entire staff, as well as annual OSHA audits, not just to confirm compliance, but to identify areas where we can do better. The safe fabrication shops follow OSHA regulations because it takes real commitment to employee safety to operate that way. It comes down to one simple question as a business owner: do you want to invest in worker safety or not? Over the past week, I've spoken with friends and colleagues across the industry. Many of them have been named in 50 and up to 100 different lawsuits. Several have already spent hundreds of thousands of dollars just trying to defend themselves while paying higher insurance premium renewals or not even being offered a renewal at all. Two of them told me they don't know how they can keep fighting because the legal costs and time demands are overwhelming. They're being forced to choose between defending themselves and actually running their small businesses. That's what brings me here today. I'm not just here for my company, I'm here to represent the very fabric of our industry. Family-owned businesses that were built with hard work, sacrifice, and responsibility. This past Saturday, I met with my dad at our office. He got emotional and said to me, "I remember starting our business on our couch, and now look at you, you're going to Congress on behalf of our industry." That moment really put into perspective what this hearing means, not just to us, but to so many families whose livelihoods depend on these businesses. I'm truly, truly honored to be here testifying before the subcommittee on behalf of our industry. My hope is that we can refocus accountability where it belongs, on workplace safety, OSHA compliance, and the parties who control fabrication practices. Thank you.
Thank you. Dr. Michaels.
Good morning, Chairman Jordan, Ranking Member Raskin, Chairman Issa, Ranking Member Johnson, members of the subcommittee. Thank you for inviting me to testify. My name is David Michaels. I'm an epidemiologist and professor at the George Washington University Milken Institute School of Public Health. The views expressed here are my own and do not represent those of the university. From 2009 to 2017, I was Assistant Secretary of Labor for the Occupational Safety and Health Administration, the longest serving Assistant Secretary in OSHA's history. From 1998 to 2001, I served as Assistant Secretary of Energy for Environment, Safety, and Health, charged with protecting workers, the community residents, and the environment in and around the nation's nuclear weapons facilities. Under my leadership, OSHA issued a long overdue and strengthened standard to protect workers exposed to silica dust. The message of my testimony today is very straightforward. Silicosis is a deadly, devastating, and thoroughly preventable disease. And the artificial stone fabrication industry is one of the most hazardous of all industries where workers are exposed to silica. There's a global epidemic of silicosis among these workers. Over the last few years, hundreds of these workers have been sickened by silicosis, dozens have died or needed lung transplants. The number of cases is alarmingly high and growing rapidly. The enormous costs of treating these cases, including lung transplantation, are borne primarily by taxpayers. Passage of H.R. 5437 would prohibit lawsuits against the corporations that manufacture artificial stone. Lawsuits play an important role in public health protection. If lawsuits by workers with silicosis are prohibited, these manufacturers will make no effort to prevent more workers from dying or becoming disabled by silicosis. We should not allow the carnage to continue. There are safe substitutes that make equally fashionable countertops. Shifting to substitutes will result in no loss of American jobs. In California alone, in the last few years, almost 500 workers have been diagnosed with silicosis. 27 have died, 52 have undergone lung transplants. And these are just the cases in California where there's a surveillance effort to detect new cases. There are undoubtedly thousands more cases across the country, since artificial stone fabrication work is no different in Washington State, Washington, D.C., or anywhere else in the country. These cases are there. We haven't seen them yet. Now, with so many new cases on the horizon, the artificial stone industry is asking Congress to prohibit lawsuits by workers sickened by their product. They blame fabricators who don't follow OSHA's silica standard. The manufacturers know their product is being used unsafely, but they do absolutely nothing to stop it. Other industries that manufacture hazardous products take a very different approach. They practice product stewardship. Responsible firms in high-hazard industries consider the risks faced by downstream users of their products and endeavor to limit or mitigate those risks. Instead of asking Congress to protect them from lawsuits, beryllium and chemical manufacturers work with downstream users to ensure workers are safe, and by doing so, they also protect themselves from lawsuits. When dozens of workers in microwave popcorn factories were diagnosed with a terrible lung disease, bronchiolitis obliterans, or popcorn lung it was called at the time, caused by exposure to the chemical diacetyl, the industry faced many lawsuits. It didn't blame the popcorn companies. No, it hired expert physicians to implement a national lung disease screening program and provide treatment for the sick workers. The firms replaced diacetyl with a safer substitute. The result was a win-win. There are no more workers getting sick and no more lawsuits. The epidemic of silicosis in artificial stone workers was identified in Australia before we saw it here. Australia has not banned lawsuits. After careful study, Australia banned the deadly product. This forced manufacturers to use a safer substitute, which they sell, and they earn profits through these sales. The same Australian workers are still fabricating countertops, but unlike those workers in the United States who fabricate countertops from artificial stone and are at risk for silicosis, these Australian workers are able to go home to their families at the end of their shifts as healthy as when they started their day. Passage of this misguided legislation will ensure that this does not happen here. It promises to be a death sentence for workers who fabricate these countertops here in the USA. Thank you so much.
Thank you. And with that, we will go to Mr. Fitzgerald for his round of questioning.
Well, thank you, Mr. Chairman. This hearing today reminds me of a lot of the other hearings that we've had in this Congress and previous Congresses when we focus on the specifics of maybe the industry and not focus so much on our broken system, which continues to be exploited and leveraged in so many different ways. And the stories that we've already heard are once again testimony to something that this committee should be examining, which is fixing the judicial system instead of going after people that are caught up in it. Ms. Schultz, I'd like to begin from your testimony. You state that over the last 20 years, Cambria has itself successfully fabricated only Cambria quartz slabs and has done so without a single reported case of a fab shop worker contracting silicosis or other occupational diseases. You also state that after more than 10 million labor hours, excuse me, in our fab shops, not a single Cambria fab shop worker has reported occupational disease, including scoliosis. Is that correct?
Yes, absolutely. And I should note for the record too, we started small. The company was not the size that it is with 1,800 employees when it first opened in 2001. We had a very small fab shop with a single saw, and we still controlled exposures to silica. Also, remember the industry that we plugged into was the existing stone slab manufacturing and fabrication industry, which cut quarried stone as well, which has varying degrees of silica content. And one of the stones that's cut now and is most popular is called quartzite, which is a quarried stone like granite or marble, where a big piece of stone is removed from the earth and then sliced into slabs. And that type of quarried stone has silica content ranging between 90 and 99%. And so it's just not true that engineered stone or quartz is the cause of these workers' problems. And of course, their plight is incredibly sad, but until and unless these workplaces are addressed, the illnesses will continue.
So when workers follow OSHA workplace safety mandates, the risk of silicosis or other occupational diseases is negligible at best. Is that correct?
Yes, and we rely, of course, on OSHA, both federal and state OSHA, to set the appropriate regulations and the appropriate permissible exposure limits for the products that we work with. And this is true for any workplace in America. We are all bound to provide our workers a safe workplace. And so at Cambria, we do that in compliance with OSHA's regulations, and we are able to control our employees' silica exposure to below the action level, which is half of the permissible exposure limit. And those are the limits that were set during Dr. Michael's tenure at OSHA.
How many lawsuits is Cambria currently facing over silicosis?
Yeah, we're currently defending approximately 400 lawsuits, most of which are pending in California state courts. While 2 have gone to trial, it's simply overwhelming to defend against this numerosity of cases. And the chilling reality is that the lawsuits are doing nothing to address the workplace conditions. Going after the good manufacturers simply is not fixing the problem.
And in dollars as a result, any idea
Yeah.
what that number would be?
Yeah, of course, it's hard to estimate, but I can tell you that it costs millions of dollars to defend a case all the way through trial. And then, of course, there's the potential for a nuclear verdict. These workers are very injured and very sympathetic. And so when they go to a jury, it's a perfect case for a products liability lawyer to have the opportunity to show a very endangered worker. They're very difficult to defend.
Very good. So let's envision a world in which the trial lawyers win a few massive verdicts and businesses are now facing millions of dollars in litigation exposure. What does that mean for both the availability and affordability of stone slab products like kitchen countertops? Mr. Talwar, I mean, what are you guys anticipating could happen down the road?
For a small business like us, we're just being hammered. So the misconception in our industry is that big business makes up this entire industry, but in reality, 95% of our industry is family-owned businesses, and that's across the country. We're not taking away from the severity of silicosis and how serious this is, but it is ultimately we're out of control of how it's cut and how it's processed. Now, if you take away quartz slabs altogether, there's still other stones that are being cut, quarried stones that are being cut. Those produce dust. If you're not controlling the actual fabrication of these stones, there's still dust. If you breathe that dust, it still has silica. If you're breathing in silica, the problem doesn't go away. So as far as cost goes, I couldn't even imagine a world where if stone went away and quartz went away, what are you putting on your kitchen countertops? So I couldn't even answer that question.
Thank you, Chairman. I yield back.
The gentleman yields back. We'll now go to the ranking member of the subcommittee for his opening round of questions.
Thank you, Mr. Chairman. Ms. Schultz, you work for the billionaire owner of Cambria, Marty Davis, correct?
I'm the general counsel at Cambria, yes?
And Marty Davis is a well-known election denier and contributor to Donald Trump, correct?
Representative Johnson, I'm not here on that topic today. I'm here to talk about stone in our industry and what we can do to try to keep workers safe.
Let me ask you about stone in the industry and fake stone. We give immunity for some medicines and some vaccines, and those are highly regulated, and they go to market and directly benefit people's health. And we also give immunity to some defense contractors who are creating weapons for use in war to protect our national security. Are there any national security implications to the manufacture of fake stone, which your company, by the way, is the largest fake stone manufacturer in the United States by far? Is there any critical national defense contribution that the company makes with this product?
Yeah, first of all, this new term, fake stone, I'm unfamiliar with, but I understand.
Let me, is there any, it doesn't cure any diseases or anything like that, does it?
Yeah, I'm here to tell you
Call it
that.
artificial stone, I call it fake stone. I don't think there's much of a difference. But let me go to Dr. Michaels. Dr. Michaels, in your testimony, you discuss how other industries that manufacture hazardous products take a very different approach than the fake stone industry. You call it product stewardship. What is product stewardship?
Dr. Michaels, could you either get closer or turn on the mic?
Thank you. Yes, excuse me. Yes, the term product stewardship is used widely in industry. The American Chemistry Council, which represents most major chemical manufacturers, has a responsible care program, and they recognize that their products are dangerous, though many far less dangerous than the silica released by artificial stone. And they say, we will work with companies who buy our product to make sure they're safely. In fact, they reserve the right not to sell their product to companies that misuse their product so workers will be endangered. That is a basic principle that many companies follow, and certainly this industry should follow. But obviously, these products are being sold to companies. Yes, they break the OSHA standard, but they know the manufacturers know that's what's going to happen. In fact, hot off the press, last night, the California Department of Public Health issued a new dashboard that says the number of factories that have reported silicosis cases, and it's 54% of all the fabrication shops in California are reporting silicosis cases. So these aren't bad actors that Chairman Issa is talking about. This is the entire industry, and this is who Cambria is selling to.
So when you manufacture an inherently unsafe product, and then you try to shield yourself from liability for it by blaming downstream users of the product, like people who cut it, and you offer immunity to the manufacturer, what does that do to hurt the health and safety of American of workers in America?
It is extremely dangerous because if manufacturers sold a product that was safer or just refused to sell it to companies where they know that workers are going to be hurt, we wouldn't have any more silicosis cases.
So, and you say that there are safe substitutes for fake stone. Can you go into that?
Yes, you can make equally fashionable, beautiful, artificial, stone countertops using a recycled glass product. It's called amorphous silica. It's a different silica. It's not respirable crystalline silica that OSHA has a standard for. It is far safer. And the major manufacturers of the world, other than Cambria, sell this product in Australia. Caesarstone, Constantino, they make this product. You wouldn't be able to differentiate the countertop made with recycled glass from the ones made with artificial stone, and it doesn't kill people.
Well, that sounds like a viable alternative that perhaps litigation and hitting the pocketbooks of these manufacturers will bring about.
That certainly is my hope. We shouldn't be discussing immunity from litigation. We should be discussing banning this product to make it safe for workers, and that would protect the manufacturers and the distributors as well.
Thank you. With that, I yield back.
Thank you. Just to make sure the record was accurate, the ranking member said inherently unsafe product. Is that part of your testimony, that the product in any form is inherently unsafe, or that it is possible to be safe? You're off again.
Yes, the product made by Cambria as it comes out of their factory is a slab. It's not unsafe, but what has to be done with that product is to mechanically remove surfaces, generate silica that's coated with resins, which is far more dangerous than natural silica, by the way, into the air, and it becomes dangerous at that point. It's like tobacco. A cigarette is produced by the factory. If it sits there on the table unused, it isn't dangerous. but if you light it up and breathe what's coming out of it, it kills you.
Thank you. That wasn't just for clarification. We now go to the chairman of the full committee, Mr. Jordan.
Thank you. Ms. Schultz, 400 lawsuits you're facing right now?
Yes, sir.
Any of the plaintiffs in those lawsuits work at Cambria?
No, none of them.
Not one of them, right?
Not one.
Any workers at Cambria have silicosis?
No, none of them.
No one's got the disease. No one's filing suit against you. Now, the doctor just said, do you guys cut, grind, and these slabs, you're doing all kinds of work on, at least that's what I saw in the video, is that right?
That's right.
How many people work at Cambria?
1,800?
No one's got it, no one's a plaintiff. How about you, Mr. Talwar? Any of your employees plaintiffs in these lawsuits? It's mostly happening in your state if I got the facts
No,
right.
sir, zero.
Zero? Any of them have any problems?
Zero.
You handle the same product that Cambria handles, is that right?
Yes, sir.
Yeah, and isn't it true, Ms. Schultz, that you got a university, because Dr. Michael said you guys are the bad guys, you should stop altogether, but I think you got a place where you actually train people to do what you're obviously doing, and no one's getting hurt. The same thing with Mr. Talwar and his family-run business. You're training people how to handle this product appropriately, is that right?
That's right, and Cambria University started in 2005 as a learning and knowledge exchange center for stone fabricators and installers.
20 years ago, you started telling people, here's how you do it. We got 1,800 employees. You've had probably people work for you and retire. No one gets the disease, and yet Dr. Michael says you should go out of business.
That's what it sounds like.
That's one of the dumbest things I've ever heard. Just do it the right way. That's all we're saying, right? All right, Mr. Heap, how about you? How about the other folks that you represent? Are they doing the same thing that Mr. Talwar's family-run business is doing and Cambria is doing? Are they doing it that way as well?
I will tell you that there are a lot of fabricators that are operating compliant shops. They're bringing OSHA in every year. Many are now doing medical surveillance of their employees, and there's outrage around the good fabricators as well that a few bad actors are causing this.
Now, is there any indication that the trial bar bringing these suits are working with these few bad actors? Is sort of some organized operation to go after Mr. Talwar's family-run business and Cambria? Have you seen that, Mr. Heap, in your industry?
What I've seen is that there are a lot of small to medium-sized companies who are selling slab material, now wondering if they're going to be in business in the future because of the weight of these lawsuits.
All right. Now, I think I got this right. This is primarily happening in California. Or how many of the 400 suits are in California, Ms. Schultz?
95% of them.
95%. And I think you if I may not have heard this right, but I thought you talked about the unions in California don't want what Mr. Michaels is suggesting. Is that right?
Oh, that's right.
Yeah, because I heard the ranking member talk about we need to be workers and unions. Fine, but they don't want this stuff put out. They don't want you put out of business. They want to do this in the right way. Is that accurate?
Yes, they do it safely, and they know that it will cost jobs if there was a ban of this product.
Yeah. That's why Mr. McClintock's legislation makes so much sense. I will yield the remaining minute and a half to the guy who sponsored, the chairman of our immigration subcommittee, the remaining time for him to ask some questions.
Gentleman's recognized.
Well, thank you, Ms. Schultz. You testified your single company is facing about 400 lawsuits, mainly from California. What control did you have over the practices that caused these injuries?
Absolutely none, but of course...
Was the only role of your company to sell a safe and legal product to a willing buyer?
Yes.
Isn't that analogous to a lumber company being sued because they sold lumber to a builder whose employees were then injured because they refused to follow safety laws?
Yes.
And because of the illegal acts of these buyers, have you been ordered to pay millions of dollars of damages that you did not cause and had no way to prevent?
Yes.
California is a sanctuary jurisdiction. It controls Cal OSHA. It appears they're just turning a blind eye to law breaking by sweatshops that are breaking our immigration laws, labor, health and safety laws, exposing their employees to the dust that causes silicosis. And it appears that instead of enforcing the law against these illegal practices, the Democrats prefer to drive you out of business. So tell us, what's the future of your employees and their families if this injustice isn't corrected?
Yes, our U.S. manufacturing jobs really matter. They matter to our workers, to their families, to our communities.
And these people will all be decimated if this isn't corrected. And of course, if these sanctuary jurisdictions were actually enforcing the law against sweatshops that are breaking our immigration and labor and health and safety laws, workers in these shops wouldn't be injured in the first place. Am I correct?
Well said.
Right. If their employers followed the law, they would not be sick. Silicosis is preventable.
I thank the gentleman.
Excuse me, Chairman Jordan misquoted me or made a misstatement about what I said. May I correct that?
Briefly, of course.
Well, Chairman Jordan said I want Cambria to go out of business. That's absolutely not the case. I would like them to sell a safer product or ensure that their product isn't
Just
bought.
change their entire business, that's all. Yeah.
Well, every other
Change
major
what you're doing, even though
manufacturer
it's
has done
safe,
this.
even though there's no plaintiffs, even though none of their employees has silicosis, but change everything you're doing. Such a deal. Such a deal. The smart professors telling a business that is operated safely, such a deal you're telling them what to do.
Well, you and I clearly disagree.
No. That's the fact. That's what you testified to. That's why I said it that way.
No, I said other major manufacturers have all shifted to a different product that's safer, and Cambria can do the same.
Guess what? We want you to change. You can't be in the lumber business anymore. That's the same argument. It's ridiculous. Yeah. It is ridiculous. Just do it right.
Dr. Michaels, are you satisfied you were able to get your answer in?
It's on the record. Thank you so much.
Thank you very much. And with that, we go to, who do we have next? Ms. Ross? Oh, the ranking member.
Mr. Chairman, thank you very kindly. You can stay in a business that is inherently dangerous if you want to. The chairman's right about that, but you've got to follow the law when you do it. Now, as I understand it, Dr. Michaels, and please clarify this for me, because again, we're not a jury. It's starting to sound like people are making closing arguments before a jury here. We just want to make sure the law is being properly enforced, okay? Here's what I understand is going on. Ms. Scholl testifies, and to my mind, perfectly honestly, that they've not had no cases from the fabricators that they work with within their own business of silicosis. They've not been sued by their own fabricators, but they weren't sued by fabricators. They weren't sued as a fabricator. They were sued rather as a seller and a manufacturer, because there's a whole different apparatus of law that applies to manufacturing something, putting it into the stream of commerce, and selling it to people. Now, as I understand it, they were held liable in cases because they did not comply with the duty of care and there was a failure to warn. In other words, they were selling to people without warning of the inherently dangerous properties of their product. It's like your example of the cigarettes. Cigarettes are perfectly safe until someone smokes them. Well, if you're the manufacturer of cigarettes, you know people are going to smoke them. And of course, Cambria understands how their product is going to be used and that it is going to be part of a construction process. But they have not engaged in the proper reasonable failure to warn. They don't like the consequences, which is that they've been sued for it and they've been held liable in court. I don't know what it is we can do about that. If you want to change the laws of product liability, if you want to change the laws of failure to warn, go ahead and change them, change tort law, but don't come to the Congress and expect us to essentially destroy the tort laws of 50 states in the country by giving immunity to one business because it happens to be owned by a friend of Donald Trump's who's a billionaire Republican donor. Right? Come on, this is like ridiculous what we're being asked to do, which is why we're getting letters from the American Lung Association telling people not to support this. The AFL-CIO has sent out a message about this. Now, to be clear, Ms. Scholl, let me just give you a chance to answer what I just said. You talked about Cambria University, where you educate on the proper methodologies for using your product. Is that right? Is that what that does?
It's broader than that. It's really a knowledge and learning exchange center where stone fabricators and installers from around the country can come together and share best practices.
Okay.
And of course,
So are your buyers required to go through that process?
No, but
Okay.
we
So
do
you're
provide
selling
safety data.
you are selling to the bad apples you're denouncing today.
No.
Basically. No, you're not?
Well, I can tell you.
Yeah.
There are 400 cases, so I can't speak to all of them. But for the
Yes.
2 cases that went to trial, including the one where Cambria was found liable.
Yes.
And has a $10 million judgment against it.
Yes.
Even though the employer was responsible for 70% on the verdict form.
And you were found
We-
responsible 10%, is that right?
We never contracted with that employer to sell slabs to him. Same thing with the second lawsuit.
Okay.
We're facing lawsuits
You were
where we.
you were the upstream supplier that got down to them. But in any event, that's what tort law is all about. We're not a jury. Somebody worked that out and said you were 10% liable in that case, and that's what you ended up paying. So, but I don't understand exactly what your complaint is. I mean, nobody wants to be sued in America, but the alternative is that we have lots of people who are wronged all over the country, who are injured and damaged. I mean,
Mr. Raskin, may I
yeah.
explain, please?
Please.
Thank you. So the intent of HR 5437 is to address the situation where third-party misuse is the cause of injury. So
is it any cause, not the complete cause, but well,
in these
there's the
cases-
problem right there. In other words, you're basically saying you
Mr.
want
Raskin-
them to take 100% of the rap for it, and you don't want to take any responsibility as a seller of it, but that's not what the law is in California.
That's absolutely incorrect, Mr. Raskin.
Okay.
If I may finish,
Please.
Thank you. Cambria, according to HAZCOM, identifies the potential hazard of respirable crystalline silica when stones are unsafely cut in violation of OSHA's requirements. It's on our safety data sheet dated
Forgive me,
back
I
to
only have 9 seconds
2001.
left. Here's what I got to correct in what you're saying. You can't just pin it on the regulators, okay? That's like saying if somebody drives and smashes into your car, but they weren't violating the speed limit, they're not guilty. Just because you are within the state's regulatory system doesn't mean you have not behaved unreasonably with respect to the rights of another person. That's why we have the tort law system. Otherwise, everything would just be criminal law and regulation. So it's not enough to say, well, we've got OSHA out there, OSHA will take care of it.
I apologize. I don't follow all of the example of the automobiles, but
Yeah.
with respect to cars, we don't sue car manufacturers when somebody speeds or drives drunk. Car manufacturers still get to exist, even though people criminally
Absolutely,
use
but
their products.
if the car is created with certain product deficiencies in it, and there are liabilities in the way it's been constructed, the auto manufacturer and the sellers are all responsible along the way. That's exactly the situation you're in.
I disagree, Mr. Raskin. The language of the HR 5437 that's proposed is limited so that we're only seeking relief from these lawsuits that are being caused by the illegal misuse, oftentimes which might be criminal.
No,
in
you're
these
looking for
workplaces.
categorical absolute immunity
That's
in all of
incorrect.
these cases.
That's incorrect.
So when would you be liable?
If there was a genuine defect in the product that made it so that in
Yeah,
normal use it was
But on your
causing the illness,
definition,
that
there's
would be
no
different.
defect in the product, right? So how could you ever be held liable? You're basically saying you're not responsible for educating anyone downstream.
That's not at all true. We do educate downstream, and we take responsibility for what we need to do. This is a copy
Well, then a
of
jury
our
found you had not
label.
done it. A jury found you didn't live up to it,
No,
but then
that's incorrect, Mr. Raskin. I don't believe failure to warn was even a claim, or even went to the jury in that trial. I'll double check and confirm that in my written testimony. But no, there was no failure to warn because people testified that even if they saw the label, they wouldn't do something differently. We know of situations where there are sick workers who have been diagnosed with silicosis, who have been to the doctor, who have been told they have silicosis, who are being deposed and literally leave the deposition so they can go back to work where they are overexposed to dangerous silica dust. This problem is much larger than
All right.
whether or
You
not the
described it
stone-
as a couple of bad apples
If the
don't
gentleman,
sell.
I've been very,
Yeah, yeah.
saying if the gentleman will, has something new, I'll allow it, but let's be brief.
Yeah, I'll close with this question then, because you've described it as basically a handful of bad apples, although Dr. Michaels said that silicosis is showing up, I think, in 50% of the cases, so that he describes it as pervasive in the industry, and that's a question of fact a jury would have to figure out. But if you know who these bad apples are, if they are the illegal, immigrant sweatshops that Mr. McClintock described so vividly, why do you sell to them? Why don't you just stop selling to those people and making sure it doesn't get down to them?
Yes.
Ms. Schultz, you can answer that.
Thank you very much. We have no interest in selling to unsafe shops. There is no benefit to us. The people who are making money off of the backs of these workers are the fab shop owners themselves. They are cutting corners by dry cutting. It costs more money to do this safely and to use water properly and to use the right equipment and to follow OSHA's laws. Those are the bad actors that are making money off of this. Cambria and other manufacturers and other members of the industry have been trying to work with the Cal OSHA board to try to get some sort of licensing or certification program in place so that we can only sell to certified, licensed, acceptable fabricators. We want that legislation. It was part of SB 20, which recently passed in California, but unfortunately that certification requirement was pulled from the bill at the last minute. We're doing everything we can to work with Cal OSHA and other regulators in California to try to promote worker safety, to try to educate people in the industry about this problem. And the very reason that we're really here today is to help raise awareness to the problem and to seek relief from this onslaught of lawsuits that threaten our good American manufacturing jobs and jobs throughout our entire industry.
Mr. Chairman, thank you for your patience, and it does sound like it's overwhelmingly a California problem. I hope you guys in California can work it out, and I assume that you can. Thanks.
I thank you both. We now go to the gentleman from Texas. For his.
Can we start the next hearing at 7 a.m. if everyone's going to have 10 minutes to talk? The first 3 minutes of the last 10 were spent talking about how you had no disclosure, you made no awareness to the consumer about any safety issues. Isn't it true that there are safety warnings that you all publish and spread and make sure people are aware of? What's that you held up?
And here's an example. This is the safety warning label that's provided in English and in Spanish on all of the slabs that leave our Cambria factory.
That can't be right, because the first 3 minutes of the last 10 were spent telling you how you didn't warn any consumers of anything. So are you lying now?
Oh, no, I apologize. I think I was confused by the questions, too.
Yeah, it didn't make any sense, did it? I mean,
Not to
you
me.
very clearly make a point to say there are dangers involved with this product, right? I can't read it from
Yes,
here, but I
yeah.
suspect that's what it
It
says.
says no dry cutting, no dry grinding, no dry polishing. The first thing.
So the first 3 minutes of the last 10 before me were just a complete waste of this room's time, because you very clearly make a point to let folks know there are safety issues here. Isn't that what you did with that sheet? That's what it says, right?
We want it to be very clear to fabricators. They should not dry cut. And if they want to dry cut, they shouldn't be in business.
Well, I'm sorry for all the misinformation that seems to be coming to whoever might be crazy enough to be watching this hearing today, if they haven't turned off after the overtime. I want to go to you, Mr. Talwar. I've seen you writing down. Can you share with us what's on your mind that you haven't gotten to say?
Thank you for the question. I'm just a little guy at this table, but I'm representing a huge, huge chunk of our industry that feels that we're put in a corner, and how do we have a fighting chance? A couple of my notes I made, the cigarette example, there's a warning label on it. Even if you read the warning label, regardless, it's still bad for you, right? If you put a warning label on a slab, but you do it the right way, it's not bad for you. So that doesn't really apply to our industry. And another thing is, say you take quartz away, it's just gone. You ban it, you do what Australia did. They're still cutting granite, they're still cutting marble, they're still cutting quartzite. There's still dust, there's still silica. Dr. Michael said that the type of silica or the percentage of silica is different, but at the end of the day, it's greater than zero. Even if it's 1% silica, there's silica in it. If the shops that are cutting the wrong way aren't doing it right, it's still bad for them. And in our industry, with all due respect, it's common sense that if you cut it wrong, it's bad for you. So yeah, those are a couple of my thoughts.
Thank you, Mr. Heeb.
I want to remind everyone that the numbers in California are rising. And every month, hot off the press, they will say the numbers are rising. We're over 400 cases right now. But you have to put it into context. The first 100 cases, between 10 to 12 of the first 100 cases were from one company. Let that sink in. less than 15% of those first 100 employees were covered by workers' comp. It is inappropriate to say 50% of the fabrication facilities in California have a silicosis case. Those numbers are being taken out of context. A lot of those numbers are coming from a select few number of companies. So we just have to put that in perspective. Is there a perceived epidemic? Absolutely. We have got to focus on getting shops doing right, operating in compliance with OSHA, but it is not fair to, while we're working with trying to get more fabrication shops to be in compliance, that companies like Gary's and so many others that I spoke about are wondering if they're going to be in business next year.
Well, I appreciate you. I'm sorry for what you're going through. I hope we get this fixed. And I yield my remaining 7 minutes to the chairman.
I think he meant me, but I just want to ask one quick follow-up, and whoever feels most qualified. If you don't have workers' comp in California, aren't you breaking the law? How do these people not have workers' comp? Mr. Heeb?
You know, in California, there is a fund that is established by the state that will pay the medical expenses of those that are
When
not
somebody
covered.
is illegally employed.
Illegally employed. And yes, I mean, the fabricators that are up in arms about this are just saying, just hold everybody accountable to operate as a legal business.
So if the state were enforcing against these people aggressively, many of these people wouldn't have received that disease because they would have been in a protected environment.
That's what we want, is we want those employees in a protected environment, yes.
Thank you. Mr. Neguse.
Thank you, Mr. Chairman. Thank you, all of our witnesses, for being here. Thank you for your testimony as we consider the legislation from my colleague from California. Ms. Schulte, is it Schulte or Schulte?
Schultz is fine.
Schulte is fine. All right, that's all right. My Neguse is tough to pronounce. Help me understand. I want to just kind of paint a broader picture. Is it correct to say that there is only one large-scale quartz slab producer in the United States of America, domestically manufactured?
No, that is untrue.
That's untrue?
Yeah, there are plants in Tennessee, and there are plants in Georgia. There have been plants
companies are
in Florida. Sure. LG, also known as LX, Houses. There's Doll Tile, which is a subsidiary of Mohawk Industries.
And do those, let me put it a different way, in terms of market share, I guess it's your contention that the other companies that you're mentioning have similar market share as you do?
I'm not saying that. I'm not.
Okay.
Yeah.
I guess let me take a step back, because I don't think this is something that your company would deny. You are the largest large-scale quartz slab producer in the United States. Is that false?
I believe it's true that we produce more domestically made quartz than any other company, but I would note that the other companies that I mentioned also do import products, so
That's
it's
fine.
difficult to distinguish.
Yeah, but I'm talking
the
about
market
domestic
share.
manufacturing. I mean, my assumption is something you'd be proud of. It's not something you would be avoiding, that you all produce more domestically large-scale quartz slab than any other company in the United States.
I think that's right.
Okay. And this bill would give you immunity, your company, I should say, the company you work for, immunity on the grounds that you've described. And I was watching some of your testimony here in the judiciary room. That's correct, right?
Only with respect to third-party misuse of the product during the fabrication process.
Got it. What other industry has the type of immunity as a matter of federal statute that you're seeking here?
That's a good question. I'd say, what other industry that's as important as the building materials industry and the stone industry with thousands of
No, I'm not.
jobs
It's
in
not a rhetorical
America
question. Sorry.
are under this kind of threat of litigation?
Ms. Schulte, it's not a rhetorical question. I'm asking you, you're here on behalf of your company,
Yes.
asking the United States Congress to pass a law that gives your company and other companies like yours immunity under federal law from litigation by countless citizens across the country, as we've heard. I'm asking you, are there other statutes that you are trying to emulate here, other types of immunity that have been given to other industries that you're seeking to emulate?
The situation here is that
There are none? I don't, I'm trying to the answer is either I don't believe there's any other industries that have this type of immunity, and so here's why we'd like to convince the United States Congress to give us immunity, or the answer is no, these are the other industries that have similar product liability immunities.
So the other examples of immunity, without speaking to whether they're analogous or not, could include things like the airline industry after the terrorist attacks, where, for example, and there may be others, and I'm happy to address that in my written responses.
Okay, well, I would love to be able to review written responses from you and perhaps the other witnesses, because as I understand it, the other examples are few and far between. The gun industry, which has secured liability protections from the United States Congress, right? The defense industry, and under certain circumstances, vaccines. So guns, bombs, vaccines, and luxury kitchen countertops, slab, quartz products. That's the list that this august body will have built in terms of giving immunity to different industries. I don't really understand. I understand the arguments you're making, Ms. Schultz, and the other folks in the industry, and I respect your point of view. But I think these are arguments that are best positioned to be delivered to a jury, not to the United States Congress. You have ample opportunity to make the case to juries. In some cases, I suspect you will lose, as you have. In other cases, you may win and convince a jury that there shouldn't be disproportionate liability on your particular industry or in terms of determining how liability will be, sectioned out and bifurcated. But asking Congress to give you blanket immunity under the circumstances you're describing, that this Congress is only afforded to the gun industry and the defense industry, which, by the way, we should not have done in those instances. But that's perhaps a hearing for another day, if the chairman will indulge us on that front. I just don't really understand what we're doing here. But.
Oh, and I'm happy to explain. And I hear what you're saying. It's a unique request that we're making here today, and that's because we cannot defend against 400 lawsuits. What's happening in California state courts is effectively regulation through litigation, and it's having a nationwide effect on businesses across the country. So that's why we're here coming to Congress today. The overexpansion of very basic tort principles threatens our entire industry.
Do you
and to the
appreciate the
extent that
enormity,
happened
Ms.
to other industries, it may also be appropriate for Congress
The gentleman's
to step
time
in.
has expired. I'm sure this will be further explored by additional witnesses. We now go to Mr. Fry.
Thank you, Mr. Chairman. And I think the witness is correct that this is far beyond just a California issue. There's a company in South Carolina, Elite Courts, that is also facing similar lawsuits. And so while this issue is new to me and we're studying it, really appreciate the testimony of the witnesses. And with that, I'm going to yield to my good colleague, or my good friend from the state of California, Mr. McClintock.
I thank the gentleman for yielding. Mr. Aib, we've heard that Cambria employs 1,800 family breadwinners. How many depend on your industry nationally?
We have nearly 2,200 members, of which over 500 of them are stone distributors like Gary.
When you say members, you're talking about companies. How many Americans depend upon your industry for their livelihoods?
Oh, they're clearly over 100,000, easily documented.
And these are mainly family-run businesses?
The vast majority of our industry is, in fact, family-run businesses, yes.
And what will happen to them and their employees and their families if this continues?
If this continues and we allow everything just to go through the courts, as has been explained, there will not be businesses in existence 5 years from now.
So 100,000 families lose their livelihoods. Is this going to prevent silicosis injuries? If these same sweatshops continue to be protected by sanctuary jurisdictions and simply switch to foreign manufactured product?
That is the heart of the situation. These companies have avoided OSHA, avoided other regulatory agencies, and they will continue to fabricate regardless of what the rules are.
Mr. Talwar, so we know that 100,000 American families will lose their livelihoods. We know that domestic manufacturing of this product will collapse, taking about $30 billion out of our economy. We know that worker injuries will continue because these same illegal fabricators will simply switch to foreign manufactured stone slabs. Couldn't that be described as a lose, lose, lose policy?
For a small business like us, we're already losing.
Well, let's look at the other side of the equation. Who's enriched by this practice?
The small fabricators that aren't following OSHA guidelines.
And are undercutting their competition by deliberately breaking the law while sanctuary jurisdictions turn a blind eye? Is that essentially what's going on?
It comes to a simple question. Do you want to invest in worker safety?
Obviously, the sanctuary state of California is not interested in enforcing our labor laws that require workers' comp coverage. They're not interested in enforcing our immigration laws that forbid hiring illegal aliens. They're not interested in our health and safety laws that require the safe fabrication of this product as legitimate businesses employ. The ranking member wished us luck in dealing with this attitude, and I appreciate that. But doesn't this affect the entire country and not just California?
Oh, absolutely. This is a problem that the entire country is facing. I said in my opening that our industry is really made of small businesses, of family businesses. And what this is doing is wiping everybody out. We're not saying silicosis is not serious. It is absolutely a serious problem. We just want it to be taken care of where it's actually happening. I'm a small business distributor. Once a slab leaves my building, I don't control who cuts it or how they cut it. I follow OSHA regulations. I do an annual audit myself to make sure we're in compliance because we spend the money and we invest in worker safety.
And you've testified that when those safety regulations are followed by legitimate businesses, there are no silicosis injuries.
None that I know of or none that I've heard of.
So this is entirely because we had sanctuary jurisdictions simply refuse to enforce our existing health and safety laws. Is that essentially what's happening here?
I believe so.
And instead, they want to sue your industry out of business and put 100,000 American families on the breadline.
Honestly, I would put it as much higher than that. And a lot of today's discussion has been about the manufacturer, and it's a serious problem the manufacturer is facing, but the small businesses in this country, we're facing a much, much bigger problem because it affects hundreds of thousands of families. I wouldn't put it at 100. I would put it at hundreds of thousands of families. And
because of the spinoff, yeah.
And I've talked to business owners across the country, and they don't know how to handle this.
Well, so much for the warm embrace of collectivism. I yield back and thank the gentleman again for yielding his time.
And the gentleman yields back. For what purpose does the ranking member of the subcommittee seek recognition?
I have some unanimous consent requests. I'd like to introduce.
Recognized.
Thank you. I'd like to introduce for the record a letter from Doctors Jane Fazio and Stefali Gandhi, leading researchers and physicians from California, opposing H.R. 5473.
Without objection, so ordered.
And explaining artificial stone cannot be fabricated safely. I also ask unanimous consent to introduce a letter from the American Public Health Association opposing H.R. 5437.
Without objection, so ordered.
I ask unanimous consent to introduce a January 13th, 2026 letter from AFL-CIO to this subcommittee, which highlights how, quote, this bill would make it safer for dangerous workplaces.
Without objection, so ordered.
End quote. Also ask unanimous consent to enter into the record a letter from the Association of Occupational and Environmental Clinics to this subcommittee, which states that the claim that stone slab producers are not inherently dangerous is false and a distortion of the facts. And they oppose H.R.
Without objection, so ordered.
With that, I yield back.
I thank the gentleman. I think
Finally.
we now recognize Ms. Ross.
Thank you, Mr. Chairman, for organizing this hearing. I actually like being at the end because I've learned so much along the way.
I hope the gentlelady knows that others may come. You never quite know you're at the end.
Right. So, so far, two silicosis lawsuits against Stone slab manufacturers have made their way through court. In one, the jury found for the plaintiff and awarded the injured worker $52.4 million in damage. But in another, a jury ruled in favor of the defendant manufacturers. So this doesn't always go one way, which is what happens when you go to court and you get the facts and you apply the law to the facts. And so far, as we've heard, there's around 500 other cases that have been filed and working their way through the court system. And Dr. Michaels, it's true that many of these cases are not in California. I even, a nice little Google search during this hearing revealed that some have been in Colorado, in Texas, in Washington State, in Oregon State. Dr. Michaels, are you familiar with those cases?
No, I'm not an attorney. I haven't really followed the cases. I mean, the legal cases, that's of less interest to me.
Mm-hmm. But have you heard about silicosis problems in other states?
Yes, I've heard about silicosis cases popping up around the country. What's clear to me is there is a system in California, a reasonably good surveillance system from Dr. Fazio and others who've weighed in here, and the word has gone out, and workers are being screened, and that's why we have these hundreds of cases. In fact, I'd like to enter for the record the statistics put out by the health department that 54% of fabrication shops in California have silicosis cases, if I can just add that.
Okay.
But we haven't seen them around the country because no
Without
one's
objection, all of your material will be placed in the record.
but we haven't seen them that many cases around the country because no one's looked for them. We have no doubt thousands of cases if there are 500 cases in California.
Okay, and before he left, Mr. Neguse handed me some information about a case in Colorado where the fabricator's small business followed all the safety standards and had this wet cutting that we saw the video of and followed what happened. And according to the information provided by Mr. Neguse, all the workers in the shop have developed silicosis, all of them. And they are now facing a nightmare. And so this brings me back to my initial statement about when things go to trial. When things go to trial, and I'll go back to Mr. Michaels and your experience at OSHA, courts look at the different fact patterns in the different cases and render judgment based on those nuances. It may be that it's one of these bad actors that we've heard about, but it may be this fabricator in Colorado where they did everything right, and you just look at all those facts. Is that correct, Mr. Michaels?
That's correct. In fact, it's very important that I correct what the chairman said earlier. The OSHA silica standard is not a safe standard. OSHA sets standards based on health effects, but also on economic and technological feasibility. So just because you're within the silica standard from OSHA, it doesn't mean you're safe. And this particular type of silica, crystalline silica that's coated with resins, is clearly more dangerous. Workers get silicosis much more quickly, younger, and they die more quickly than other workers who are exposed to silica. Let me also, since we're talking about OSHA, I have to say there's some rich irony here to talk about. If we only had more OSHA inspections, if we made sure these companies followed OSHA, the problem would be solved. You have a Congress here that is cutting OSHA as much as they can. The president's budget is wiping out OSHA. And beyond that, the co-sponsor of this bill, Mr. McClintock's colleague from California, Mr. Biggs, is the primary sponsor of a bill called NOSHA, the No Occupational Safety Administration Act. It abolishes OSHA. So to say for this Congress to talk about we need stronger OSHA protections and that will essentially save this industry, it's rich irony.
And on top of that, to have this Congress be giving immunity when we know that a product has resulted in so many people having such a serious injury in the workplace. That's another rich irony. And thank you. I will yield back.
Of course, thank
Mr.
you.
Chairman.
The gentlelady yields back. I've got a couple of things. You have a UC?
UC, if it's okay.
I'd recognize you for a UC first.
Thank you kindly, Mr. Chairman. This is from the Superior Court of California, County of Los Angeles, filed August 7th, 2024, finding as to plaintiff Gustavo Reyes Gonzalez for products liability. Failure to warn, we find in favor of the plaintiff against Cambria Company. So both in
Without
answer to Ms.
objection,
Schultz
that'll
and
be
my colleague who
placed in the
chided me
record.
for raising the failure to warn, that's precisely what the guilty verdict was about. Thank you, Mr. Chairman.
Okay,
And I apologize, and if I may clarify, one thing, and I was going to anyway, is that our failure to warn did go to the verdict, to the jury in that first case. It's on appeal now, and that's probably why I misspoke, in addition to the fact that it followed some statements about us never warning about anything at all, which just isn't true. So
I never said that, so please retract that too, if you would.
okay, we'll let the record speak for itself, but I thank the gentleman for placing that in the
We
record.
will indeed.
And with that, I'd ask unanimous consent that letters in support of this legislation, including the American Tort Reform Association, the National Kitchen and Bath Industry, that's hundreds of thousands of people over and above those you're counting, the Natural Stone Institute, the Granite Association, Inc., and then I'd like to also place into the record for reference the actual bill, H.R. 5437, so that we all have it. I failed to do that at the beginning. And lastly, I want to place into the record from the Milken Institute School of Public Health, a press release that is, a press statement that says, David Michaels briefs Congress on new silicon dust rule, in which he says, and I quote, the previous exposure limits were outdated and did not adequately protect workers, Michaels commented when introducing his new rule. Occupational exposure to silicon dust occurs when workers cut, saw, drill, or crush concrete, brick, ceramic tiles, rock, and stone products. I just want to make sure that your testimony or your quote in that case is particularly there because of the both natural and manufactured that you spoke on at that time. And with that, I have the privilege, as the unanimous consent went, of recognizing for his own 5 minutes, Mr. McClintock. I may not be the practice, but it was the unanimous consent. And if Mr. Carrera is here, he'll be recognized. The gentleman's recognized.
Thank you, Mr. Chairman. First, I want to make it clear, no one opposes health and safety regulations. Dr. Michaels, the opposition is to the combination of legislative, executive, and judicial powers in the same hands. Madison called this the very foundation of tyranny, and one of the objectives of those of us who believe in the Constitution is to restore those guardrails between those three very distinct functions of government. Ms. Schultz, Cambria not only manufactures and sells to third parties, but it also fabricates product itself, does it not?
yeah, that's right, and our workers are protected when we follow OSHA's regulations and requirements, which we do, and our workers are safe and protected, and in fact, our CEO's own children work on the floor of our fab shops.
And this because you fabricate according to all the health and safety laws, and you've not had any injuries as a result of fabrication.
That's right.
The ranking member just introduced an article that contends there's no safe way to fabricate your product, and we've heard from the Democrats that it's inherently dangerous. How does this comport with actual experience?
Yeah, from our real-world experience in industry, fabricating exclusively quartz surfaces, we know that workers can be protected by following OSHA's regulations and controlling silica exposure to below the permissible exposure limit. And in fact, at our shops, we control exposures below the action level, which is half of the PEL.
All right. Mr. Ayub?
We have many fabrication companies all over the country that are in compliance with OSHA with no cases of silicosis. with employees that have worked for them for 10 years, 20 years, 30 years. We have companies that exist in the Midwest that have not had a case of silicosis in over 50 years. So it is really important to acknowledge that there are a few bad actors that are causing this. Also in California, as Ms. Schultz already referenced, we as industry tried to collaborate with the state of California to set up a licensure program so that there would be a complete vetting process that only the good fabricators could in fact secure the product and prove that it's being fabricated safely. And all that SB 20 did was say it's illegal to dry cut, which we support, but we want them to do the next step. And so industry will continue to be front and center, helping government, working with government. But there are two issues here: the bad actors for fabrication and the unfortunate impact of these lawsuits impacting companies like Gary's and many of the small employers that I spoke about.
Mr. Tower, what of your experience?
The issue to us is it comes down to the same thing, is we know it can be done right. If it's done right, there's no problem. I think we've hammered that home. But as far as a small business, I bring product in, I put it in a warehouse, and I ship it out. Once it leaves my warehouse, I don't know who cuts it, how they cut it, or what happens. There's hundreds of, maybe thousands of companies across the country, just like myself, that are being hammered with lawsuits. We don't know how to fight we're fighting for our lives, and we can't afford it anymore.
Ms. Schultz, the equipment to protect your workers that we saw in the video looks rather expensive, is it not?
Well, the safety precautions are integrated into the equipment itself, so.
But it's expensive. I mean, you have to invest in that shielded and water protected system, correct?
So the shielded system is not the key. The key is the use of water, and that can be achieved through small handheld devices and equipment and tools that are available to fabricators. And we teach how to use those smaller saws at Cambria University.
Well, I assume, so why is it then that these illegal fabricators are not using this?
I really don't know. It's seemingly they're cutting corners and endangering their workers.
So they are saving money by not protecting their workers with these basic precautions, and I assume that gives them a competitive advantage over the legitimate fabricators that are employing these processes.
Yes, they're putting profits above people, and then we get sued out of existence.
And that seems to be the side that the Democrats have chosen in this fight, which I find rather strange. The Democrats have repeatedly referenced Donald Trump because one of his supporters owns one of the companies. I assume that's Cambria that's affected. Do you get the impression that a lot of this is political and that some of our members are missing the big picture of what this is doing to the livelihoods and safety of tens of thousands of American workers?
I'm afraid so, and we should prioritize worker safety over politics.
Yield back.
I thank the gentleman. I'll note for the record that the general waiver that I asked for under unanimous consent, the minority did not understand the broadness of it. So in order to make things equal under the intent, we will consider that I actually yielded to Mr. McClintock my 5 minutes. I now ask unanimous consent that we have an additional 5 minutes per side as a second round if the witnesses can remain that long. Without objection, so ordered, and the ranking member is recognized for 5 minutes.
Thank you, Mr. Chair. Dr. Michaels, I've heard arguments today that we should grant manufacturers immunity from liability because artificial stone slab products are not inherently dangerous when they enter commerce. Now, I don't believe it's Congress's job to litigate products liability cases, but since it appears relevant to this question of immunity, fake stone slabs have over 90% crystalline silica, toxic metals, and toxic resins in them, which generate poisonous, carcinogenic dust during the fabrication process. Artificial stone slabs are produced solely for the purpose of alteration. Are there any uses for an artificial stone slab that don't involve cutting it?
No.
So if the artificial stone product makes the air around it unsafe when cut. Isn't that just another way of calling the product itself unsafe?
Absolutely.
Dr. Michaels, medical professionals in Australia warned that it could become the next asbestosis without intervention. What do scientists mean when they refer to something as the next asbestosis or next asbestosis, and are they correct?
Yes, I mean, asbestos is an amazing mineral that's used as an insulator for fireproofing. It was very clear at the early part of the last century, even before that, that breathing asbestos causes a terrible lung disease we call asbestosis. The industry for many years tried to deny that, to try to hide it, make sure studies weren't done. But the result is that we had millions of workers exposed, and huge numbers of them developed lung disease and lung cancer, mesothelioma, other conditions. Eventually, because of their really poor judgment and not warning people, just selling it widely, most of those companies were sued, and actually they went out of business. They were found by juries over and over again to have essentially covered up what the problems were and not sufficiently warned these people. And we had tens of thousands of deaths as a result of asbestos exposure. We don't want that to happen again.
Well, what did the litigation response to the asbestos public health crisis, what did it result in? What were the ramifications?
Well, it raised the issue tremendously, and a lot of companies stopped using asbestos. The secondary companies, the companies that would use asbestos in other materials, in gaskets and brake shoes, they said, we can't use asbestos anymore, and they found substitutes. You know, litigation is like regulation in that it drives technology. Companies that don't want to be involved in litigation find better products, safer products, and they substitute. And that's what will happen here when companies say, it's too dangerous to use artificial stone, let's move to amorphous silica, which is recycled glass. We'll make a product that's equally beautiful, equally fashionable, but doesn't kill workers.
Well, that would be a product that Mr. Talwar and his firm could distribute. Mr. Hybe, all of his members could distribute. It's something that Ms. Schultz, your company could manufacture. Isn't that correct? A safer product.
No, our product is safe. The issue is when unsafe fabrication practices are used in violation of OSHA's laws.
The evidence is clear that engineered stone containing crystalline silica is too toxic to fabricate and safely install, and education and enforcement alone will probably not be sufficient to curtail the escalating occupational health emergency that is being caused by this product. You would disagree with that statement?
Yes, what needs to happen is the unsafe
Then let me ask
workplaces
Dr.
need to
Michaels
end.
then. Dr. Michaels, would you disagree with that statement?
I would not disagree with that statement. You know, it can be done safely in an enclosed environment, cost millions of dollars to set that up, and we're not going to make new countertops for the country, you know, in these very, very expensive facilities. That's just not going to happen.
What would immunity do for this industry to the public health of this country and the cost to the taxpayers?
It is all bets are off. There's no stopping the number of silicosis cases we'll see around the country. Putting aside litigation, these cases are being paid for by the Medicaid system, by VA. Lung transplants cost over $1 million each, and we've got dozens of them in California already, and they're being picked up by Medi-Cal. So it's going to impact hospitals, the public health system, and of course it's going to make many people sick.
Mr. Talwell, briefly, because you've been holding up your hand.
So Dr. Michaels said that I could easily switch over to recycled glass, but in actuality, less than 1% of my sales are artificial stone or quartz. But that less than 1% is going to put me out of business potentially. And these cases have expanded to stone as well, not just artificial quartz. So if you look at the hallways in this building that we're walking on, it's marble. That also has silica. When you cut that, it's not a countertop, as Dr. Michael said, that's floor tile. When you cut that and you cut it wrong, that will have dust and it'll have the same effects too.
I'll now recognize myself. Dr. Michaels, in this statement I put in the record earlier, you didn't say manufactured stone. You said glass, pottery, concrete products, sand in large quantity, marble obviously would be in there. All of these can exceed the OSHA guidelines if crushed or used incorrectly, correct?
Yes.
Okay, so we get rid of this industry, we're not getting rid of concrete, sand, pottery, and the like. So really it is a question, even in your opinion, that what we have to do is ensure that OSHA standards are met on the job site. Is that right?
That's a piece of it, though.
No. That seems to be the piece of it, is that no one in compliant industries, as far as we've heard in testimony today under oath, no one has contracted this disease, and yet in those 54% of California job sites, the vast majority of them appear to be illegal, using illegals, in fact, abusing primarily Latinos who have come into this country looking for work. They find work in these sweatshops, and they're too desperate to say no. And I share the union's objections to the idea that these unprotected workers are there, but are you going to protect them, or anyone, including concrete and other marble? Are you going to protect them by simply saying, let's sue the marble manufacturer, the concrete manufacturer? And I will say here today, Dr. Michaels, you appear to be supporting the idea of eliminating something that when you had the chance, you set a standard, and I'm sorry, but OSHA standards are based on safe in the workplace. Manufacturers, production, including my own when I was a manufacturer, we rely on those standards to make sure that we're below them, the decibel level and everything else. I'm a big believer that OSHA guidelines, when implemented, do make the workplace safe. And if they don't, then it's your job to lower them. So I find it amazing that just a few years ago you set a standard, and today the standard is 0. Unfortunately, Ms. Schultz, because I have a couple questions for you. The standard of 0, if you switched, wouldn't be achieved in any product, would it? That would be hard surface.
May I respond to what you've said?
Well, I'll get back to you.
Okay.
Is a standard of 0 that Dr. Michaels is implying, if you only worked with marble, you wouldn't meet that standard, or at least people fabricating in dry cutting wouldn't meet it. They wouldn't meet it in granite. They wouldn't meet it in concrete. All of that is true, right?
Right. Workers are grossly overexposed through the dry cutting process.
Are they currently suing, to your knowledge, the concrete manufacturers?
Not the concrete manufacturers.
But they are, Mr. Haib, they are now getting into the other stone manufacturers, right? So they're going after natural stone.
Going after natural stone as well.
Okay, so the fact is, although this legislation looks and targets stone, the reality is that this committee probably has to take a good look at wood, metal, and everything else that has no adverse effect when used properly, but in some case can in fact be dangerous on the work site. And it is the example of the automobile, Dr. Michaels. The automobile is an incredibly dangerous tool when used incorrectly, isn't it?
Certainly.
Okay, and yet we don't sue the auto manufacturer when someone drives drunk and runs someone over. We have a lot, we might sue the bar that had some percentage of liability, right?
Sure, if you say so.
Okay, and Ms. Schultz, my understanding is that you were held somewhat accountable for a non-disclosure, and it's up on appeal. But wasn't it far less than 50%? Wasn't it not the proximate cause, even in that case?
Oh, yes, it was only 10%.
Okay, so when a jury flips a number and says, oh, we'll hold you 10% responsible because you didn't sufficiently in their mind disclose something, at least on some occasion, maybe your manufacturer, you had 100% of the penalty because you were the one with the pockets, isn't it?
That's right, under joint and several liability.
So one of the problems here, which is a general tort problem, is you only have to be 1%, 1/10 of 1%, but have deep pockets or the other pockets disappear, and you not only bear the cost of the defense, but you bear the 100% of the damage. Isn't that true?
Yes, for the economic damages.
Well, I think this hearing has done a good job of making sure we understand why this important legislation in a industry is going forward, but that industry is the tip of what is likely to be a growing set in which this committee will likely have to come back. And with that—
May I respond?
Briefly.
Yeah, we heard from Mr. Neguse and Ms. Ross that there are cases in California of workers with silicosis who are exposed under the standard. That isn't surprising to me because OSHA standards are not safe levels. They're safer, but OSHA has to look at economic and technological feasibility, and we could not drive the level down to a purely safe level because the law doesn't allow that. In this case, we also know that the silica that comes from artificial stone is not like the silica that you get from in coal mines where there's quartz, or in foundries or construction sites, because it's coated with toxic resins and other pigments, things like that, that clearly make it even more dangerous. Furthermore, the OSHA standard that I issued in 2016, where that press release is from, the process began in 1997. We issued the proposal, I think, in 2013 or 2014. This industry barely existed, and the cases weren't there. We didn't have the research to include that.
And I've allowed you to do that, but again, I noted all the other products that you said in this. These products did exist. Concrete is not new. I'm a Californian. I've seen an awful lot of wet cutting of concrete as I drive down road improvements. That wet cutting is an example that is being done because they don't want to have all that dust from the concrete in the air. So you set standards, the standards are met, but meeting the standard doesn't give you any protection from being sued. As a matter of fact, if you, as Mr. Talwa, import a product or buy a product and sell it and never, in fact, fabricate it at all, moving something that I could lick and it isn't going to hurt me, that I could sniff, that I could use as a cutting board isn't going to hurt me. Using that, in fact, he's not exempt even though he had nothing to do with it. This is like suing the car dealer, the car distributor, and by the way, the trucking company that moved it in and out. And you're saying today, effectively, you should be able to do that. I understand the gentleman has a unanimous consent before we close.
I do. It's the story of the Colorado family that owned the stone fabrication shop in Colorado that Congresswoman Ross referenced in her
Without objection, that entire
tells the story of how they followed OSHA standards and still everybody in the shop got sick with silicosis.
Without objection, the entire statement will be placed in the record. And this concludes today's hearing. And I do want to thank our witnesses for appearing before the committee and giving us a lively opportunity to understanding a major emerging threat and one that concerns particularly California. Without objection, all members will have 5 legislative days in which to submit additional written questions for the witnesses and additional materials for the record, and I know there will be a great many. Without objection, this hearing is adjourned.